We begin with this striking day in court. The first hearing before the federal judge overseeing Trump's coup trial occurred today. So, yes, there's been a lot of news developments, and there was back and forth about the evidence. Rachel and I were discussing during the arraignment day that there was going to be an evidence clash. But today, it went to court, and the judge gave defendant Trump very blunt warnings about his behavior and the stakes. And there was a bracing message. He will be treated like any other defendant. Now, Trump did not attend the hearing in Washington today, and that's fine. You can have these kind of hearings among lawyers. His defense team entered this morning. We saw that. We tracked that. And for a hearing about what in other cases might be a more routine matter. What are the rules of evidence before you go to trial, and how can it be discussed? So this is basically the framework or ground rules. You may have heard the reference to a protective order. Now, Judge Chutkan rejected Donald Trump's request to speak in broad or general terms about some of that evidence. He will be restricted from publicly discussing the sensitive materials. The ruling came out late today, and the judge says if defendant Trump receives sensitive materials as part of this case, meaning stuff that he might not otherwise get, but for being a criminal defendant, then his lawyers may not allow defendant Trump to write down any personally identifying information. Now, that may sound like a relatively bland or standard protocol, but what it means and what it also refers to is how Donald Trump has basically been accused of credibly abusing information in the past. Indeed, Jack Smith's other case is about him stealing classified materials to use it in whatever way he wanted, and there's a tape of him using it to try to settle political scores or discredit people. So this is trying to prevent Donald Trump from doing anything like that, including up to any new crime like witness tampering. Now, sensitive is the key word because it won't apply to every piece of evidence. In this morning's hearing, the judge also issued tough warnings for a defendant who, of course, has tried to lash out or intimidate people inside the justice system. Now, I want to show you a piece of this. You may wonder what you're looking at here. I wanted to bring it up on the screen before I got to this, but you're looking at circus or carnivals. And, you know, sometimes words don't paint the picture of pictures with 1,000 words. And so I wanted to show you this carnival and this carnival-like atmosphere to share with you part of what the judge says will not be allowed. So that's a carnival. That's something we all know. And the judge went out of her way today in this first clash hearing between Jack Smith's team and Trump's lawyers to say she simply will not tolerate any kind of carnival atmosphere. The more a party makes inflammatory statements about this case, which could taint the jury pool, the greater the urgency will be to proceed to trial quickly. Now, I want to make one more point about this, and I want to be as precise and fair as possible. The judge is saying that in general. So as a general matter, if you say, well, was that shade against any which side? I think the judge would say, or a reasonable view of the transcript would be, she said, in general, no carnival atmosphere. But then we have to add the context. Jack Smith and his team have not done anything to foment a carnival atmosphere. Indeed, as we were discussing on this program last night, he barely speaks. He's spoken in public for 4.5 minutes total in 2 brief appearances in his entire tenure. So it is quite clearly the inference that the judge was speaking to the other side. No one's allowed to make it a carnival atmosphere, including the DOJ, but she's clearly directing that at defendant Trump and the people around him who have made a carnival-like atmosphere, who have selectively quoted and taken things they've received like target letters and tried to turn that into fundraising and merch and attacks on law enforcement, attacks on D.A. Bragg, who was, along with the president, named in a threat this week that was dealt with. This is a carnival and beyond, and this is the context for that admonition today. And the judge also said that defendant Trump's argument that the restrictions on what he would say would harm his campaign aren't really going to get a lot of look from her. Quote, this is a criminal trial. I cannot and I will not factor into my decisions the effect it's going to have on a political campaign for either side. Meaning, again, Jack Smith reports into the Garland Justice Department, which reports into the Biden administration. This case has independence, but the judge is saying as fairly as possible, I'm not worried about either of your campaigns. She also went out of her way to say that when it comes to the idea that there is a selective prosecution, that somehow Trump has been targeted not for what he did, but for who he is, which, if you can show evidence of that, that would be wrong. Well, Donald Trump coming up short. The judge, who again is the nonpartisan party here, I'm not just quoting Jack Smith. Here's what the judge says. I haven't seen any evidence this is politically motivated. That's a setback for any in-court selective prosecution claim. And again, this is what we've talked about, the difference between what you say out here and this defendant and his team have every right to make any claim they want. They have the freedom of speech to go out around the country and say, it's not that we got in trouble for what we did. It is that Donald Trump is being unfairly attacked, witch hunt, witch hunt, witch hunt. They have the freedom of speech to say that. What the judge is saying today in court is, so far, that is a worthless, baseless, zero-type legal claim, which means it won't help them avoid trial, and it won't be the kind of thing that they likely will be able to present to the jury unless, of course, as I said, they find evidence of it. The judge also rejecting the defense claim that, as I mentioned, the free speech rights are being challenged in court, because he has all the free speech to talk out of court. But the idea that free speech is a license to a coup or a conspiracy, that's never been true. It's not legally true. And we've heard versions of that from Trump's lawyers on air.
What the position of the prosecutor is non-sensitive, ordinary evidence should not be disclosed to the press. That's shocking. Not only do they want to violate President Trump's First Amendment rights, they want to violate freedom of the press.
Now, let's show you the quote. Defendant Trump here, Mr. Trump, like every American, has a First Amendment right to free speech, but that right is not absolute. In a criminal case such as this one, the defendant's free speech is subject to the rules, the judge explained today, adding that Trump is a criminal defendant. He's going to have restrictions like every single other defendant. The judge also saying today, quote, the defense, that's Trump's side, is supposed to happen in this courtroom, not on the internet. And to the extent your client wants to make statements on the internet, they always have to yield to witness security and witness safety. I could see the possibility for a lot of problems here. Now, what's really interesting is there is a public clash anytime you get the legal process involved. You could have the police stop someone, outside a restaurant, and if there's photos of it or discussion of it, people might think that person did something wrong, and they didn't. And Donald Trump legally is presumed innocent, and he can certainly go out in public and talk about that. But what the judge is saying here, and you'll notice she's being quite strict with defendant Trump and his team, is that while those concerns might be generally real and they're afforded a certain set of free speech rights in America, that's not a license to say anything anytime, which is to say, in trial, it's not a defense to conspiracy to say you're allowed to talk. Duh. And in pretrial, meaning in the ramp up to this trial, it's not something that means that Donald Trump as a defendant can, for example, violate the protective order rules and the evidence rules, or take sensitive information that he only got because Jack Smith's team provided it for purpose of trial prep, like here's some grand jury interviews that are secret, and just go blabbing about it or lying about it in public. He doesn't have that right as a defendant. Just doesn't. As for the real world concern that these things should be handled in court and not in public hype, well, there is a strange overlap here, actually, because we pointed this out. Jack Smith, back when he talked a little bit in the earlier days of his career, has shared the idea, the framework, that you got to be careful with this stuff because you don't want to be unfair. He talked about that's why it is generally better within trials to let the evidence do the talking and not have a society that pre-convicts people based on hype. Here is a younger Jack Smith.
We don't want to live in a society where someone is convicted based on what's in the newspapers. We don't want to live in a society of a form of mob rule where we just get a few allegations without any process, convict somebody. But I think that's the role of the prosecutors, to take allegations like that when they're public and investigate and see if the facts actually back up what's there. Is the allegation and the source of it credible? Is there exculpatory information on the other side? Is there corroborating information that makes it even stronger?
Information, evidence, facts, and discipline and restraint when it comes to the public side of all that. It's actually kind of what you want out of a model prosecutor. It is why, although I've explained before that this is an area of nuance, the DOJ doesn't have one rule about what you can say. People in law enforcement can give longer remarks. They can give interviews. But you'll notice that some of these really respected by the book prosecutors, the Mueller types, the Smith types, they err on the side of caution, which is actually fair to the defendant. Now, the judge ended this hearing saying, today I will take whatever measures are necessary to safeguard the integrity of these proceedings. That is also a warning if defendant Trump goes so far to tempt being held in contempt of court.